My name's Russ Doms. I'm the Executive Director of the Edmonton Chamber of Voluntary Organizations, and it is my honor and duty to welcome you here this afternoon. This being one of the more crisp winter days in Alberta as we all think about the days of green grass and butterflies, so it's not that far away. Let's hang in there. We're very pleased to bring you what is proven after this morning's discussion to be a very interesting and a little anxious session about the new anti-spam legislation. As you might be able to tell, this afternoon's session is being videotaped. So if you're not supposed to be here and you don't want to get caught on film, then you need to lurk somewhere. You will be captured, though, as we get into discussion. So that is part of our deal here this afternoon. The reason we're doing this is that over the coming months, there will be more and more folks who will figure out they need to know what this is about. And so we'll be making this video available online. We'll be charging a small fee. For those of you who are here and have paid to attend this, you'll be able to access it for free. So it is an ongoing resource that you can then access and share with others of your staff group or your board. So without further ado, I'd like to introduce to you the two folks who came here, especially to be with us today from Toronto. We have, first of all, and I think you'll figure out who's who here in a second, Bill Shaper. Bill's been with Imagine Canada since 2010 and is Director of Public Policy and Community Engagement. In his past several lives, he was a political staffer on Parliament Hill and a senior policy analyst to a federal cabinet minister, and a GR practitioner with the Association of Universities and Colleges of Canada, an independent policy consultant, and a value for money auditor with the United Kingdom's National Audit Office. And our second very special guest and friend is Manit Zemo. Manit's a partner and commercial litigation with the commercial litigation group of the law firm Miller Thompson, LLP, and they have an office here in Edmonton, practicing out of the Toronto office, where she advises businesses, nonprofit organizations, charities, and individuals on a variety of legal disputes. Ms. Zemo has experience and expertise with internet and e-commerce related legal issues, such as the Canada anti-spam legislation, online defamation, and cyberbullying. She's a member of Miller Thompson LLP's Canada Anti-Spam Legislation and Advisory Team of Lawyers. So before we give them a warm Edmonton welcome, I have one small commercial message for you, is that since Bill has come to Edmonton, we have scrambled together an opportunity to spend time with him tomorrow on a couple of significant items. So you can sign up for these if you haven't caught them tomorrow, or there's a little sign-up sheet that we'll sort of pass around today, this afternoon. One is on the nonprofit sector, charitable sector narrative, which you may have caught information about very recently. Imagine Canada has released a very brand new toolkit. Good information for you to learn about. So we'll be meeting with Bill on that tomorrow afternoon, and tomorrow morning, Bill is going to spend some time talking with us about engagement in public policy. So an opportunity really to connect in on a couple of very important topics. So we'll be passing that around later today, or you can sign up later today on Eventbrite. So let us give a warm Edmonton welcome to our friends Bill and Manit, and we'll get the show on the road.
Okay, well, thanks, Russ. For those of you not familiar with us, Imagine Canada is a national umbrella for the charitable and not-for-profit sector. We work with individual charities, we work with organizations like ECVO on issues of common concern, issues of common ground facing us all as organizations. I'm based in Ottawa, actually. We do our public policy work out of Ottawa, and we deal purely with federal and pan-Canadian issues. And so the spam legislation being something that's an initiative of Industry Canada, is something that we've been heavily involved with, working with various partners over the last year and a bit to really try to get an understanding for it, get an understanding for the implications, make some interventions with the government, and try to mitigate the impacts of it, and then B, work with organizations like ECVO, with some of our partners in the legal community, to get the word out to people as to what they need to know, what they need to be thinking about. It was about a year, it was January of 2013, Industry Canada published draft regulations to implement the anti-spam bill. The bill itself passed back in 2010, but couldn't be implemented until the regulations were finalized. Much to my joy, I came back from a week of vacation down in the Caribbean and found I had 3 weeks to learn about this and put together a detailed submission to Industry Canada and work with people to sort of develop our position on it. When we looked at the draft regulations, it was brutal. The definition of a commercial message was so broad that pretty much anything a charity or a not-for-profit sent out would qualify. Having your web link in a message made it a commercial message, even if there was nothing commercial in the message. Issues like that. So we put together about a 10-page brief, sat down with the officials to walk them through it, and much like I think you can relate to in dealings with government people, there was very little understanding of what the sector was about, what the sector did. They were shocked that it was going to impact on us at all. I think there's very much still a view in government of the charitable and not-for-profit sector being little old ladies in the church basement raffling off quilts and things like that. Good people doing good, which is an important part of it, but there's so much more. They had no idea the range of activities that charities and nonprofits engage in that involve financial transactions. They had no idea that certain parts of the sector even were charities. They didn't know that this was going to hit universities as charities. They didn't know that universities were charities. They didn't know that hospitals were charities, and it was going to impact on the ability of hospitals to follow up with patients, for example. So there was a lot of educating to do, a lot of lobbying to do to try to get some changes. And what we had recommended, given everything that the impacts were going to be, given the range of activities, and given that, let's face it, when people think of spam, they don't generally think of charities and not-for-profit agencies as being out there trying to rip people off or, you know, get something for nothing. We had recommended a broad exemption, a complete exemption for commercial messages sent by charities or by public benefit nonprofits. And we actually used, in terms of defining public benefit nonprofits, we looked to Alberta's lobbyist registry, which has a nice definition of public benefit nonprofits in defining its exemption, to provide them with that so that, you know, they couldn't say, how do we can't define these things. Well, it's been done. We spent the spring and the summer having various meetings back and forth, meeting with politicians, meeting with political staffers. When the cabinet shuffle happened in the early autumn, we were invited by the new Minister of Industry to sit down with a select number of stakeholders and put our positions again and try to do a last push for some change. Coming out of that, we got, you know, a partial victory. We wanted an exemption for all the activities for charities and public benefit not-for-profits. Unfortunately, the exemption that was provided was somewhat more limited than what we had hoped for, and it wasn't extended to not-for-profits. My my thinking is that they looked at the exemption that's in place for the do not call list, and that is for registered charities, and they used that as their precedent and decided to limit it to registered charities. And of course, the wording of the exemption for registered charities is just full of gray areas and things that need to be clarified, things that need to be interpreted. And we are still working with the officials to try to get that kind of clarification and that interpretation going forward. But the exemption basically is for commercial electronic messages sent by or on behalf of registered charities where the primary purpose is to raise funds for the organization. The gray areas, primary purpose. What do they mean by primary purpose? Is that a matter of real estate of the message? Is it a matter of placement of the message? If you send a newsletter out where you have something at the bottom, does that qualify as primary purpose? If you move it up to the top, does that make it primary purpose? Because they don't define that term anywhere. So there's that. And there's also this notion of messages that seek to raise funds for the organization. They don't refer to CRA's definition of fundraising, which everyone is familiar with. They've brought in a phrase that isn't used anywhere else that we can tell in any kind of legislation or regulation, and they don't define it. There are certain things that we're pretty confident in saying are covered. So pretty much anything that CRA would define as fundraising, we're pretty confident in saying would be covered. So selling tickets to a dinner, a lottery, purely asking for donations, things like that. Where we get into somewhat grayer areas is if you think, for example, of a symphony orchestra that is also a charity, and the primary way that they raise funds is through ticket sales. Now, CRA doesn't count that as fundraising. There's no tax receipt when you sell a ticket. It's just that kind of transaction. But when that is the organization's primary way of raising funds, well, they've left a little wiggle room there. We hope that maybe we can get that definition broadened to include situations like that. Or when you're offering your programming and there's a fee for service. So if you're offering English as a second language, for example, and the participants pay a small fee to participate, is that raising funds for the organization? Those are the sorts of areas we still need to clarify, and we are working to do that. There are a series of other exemptions as well, and consents and implied consents, which we'll get into through this. But the thing to keep in mind is you need to be aware of these things, depending on your organization and how you operate and the kind of messages you send, how you get your email addresses, things like that. You may have a relatively easy time dealing with this and not have much to worry about. In other cases, there are going to be some gray areas that you'll want to keep in mind, and then there's issues of risk assessment and risk mitigation. In other cases, we're hoping we'll be able to get some clarification and guidance that we can get out to people in the meantime on some of these issues. But then there are other organizations, especially if you're heavily involved in what we call earned income activities. I mean, if you run a consulting arm, or if you sell swag, is beyond fundraising, then there may be issues that you have to deal with, that you have to keep in mind. So we're hoping to highlight as many of those as we can, give you an overview of what's in there, what it says, where we can give clarity and answers on things. We'll give clarity and answers on things. Where it's a gray area, we'll be quite open with you that that's a gray area. There are circumstances there that you will come up with questions that we haven't even thought of, probably. which again just adds to what we can take to the officials, adds to our process in terms of trying to get a better understanding of this and get word out to the people that have to live with it every day. And hopefully we'll come out of here with a bit better understanding of things and a bit more awareness of things, and at the very least some thoughts on where you can go for more information, for assistance, and what we're hoping to continue to do with this. As a policy person, as a political person, to me, we have to prepare for what's there right now. We don't have to necessarily accept that it's always going to be there. As it becomes more and more clear what the implications of this are, it's not just our sector that is facing huge transformation because of this. The private sector is affected in ways that we aren't, in addition to the ways that we are. And if it becomes apparent that this is seriously impacting on our sector and its ability to go about its business and to do what it's meant to be doing, rather than dealing with red tape, rather than dealing with regulation, rather than having resources diverted away from what we're meant to be doing into complying with things that at the end of the day don't really make that much difference. There's always opportunities to revisit issues. A regulation is there, regulations change, regulations get revoked, regulations get, for a multiplicity of reasons. And so the other thing that coming out of this to keep in mind is, as you go forward, as you start dealing with the implications of this, as you start quantifying what it means to your organization in terms of opportunity cost, in terms of financial cost, that would be information that if you can get that to us at some point, because everything we get strengthens us if we want to make that case down the road for the government, whether it's this government or another government in the future, to revisit this. Because if it's having the kind of impact on the sector that we think it could have, then it's something that needs to be revisited. I don't have the quote right in front of me here, but when Industry Canada publishes regulations, they have to have an accompanying document called a regulatory impact analysis. And in that, they have to show that they have taken measures to understand what the impact is going to be on the economy and on small business and on rural communities and whatnot. And they have to show that they've met the one-for-one rule. The one-for-one rule being that if you bring in a regulation that imposes a cost, you have to get rid of a regulation that imposes equal costs. They say in here that this is going to have no administrative or compliance burden or cost on any sector of the economy. Take that for what it's worth, but it's the sort of thing that we're dealing with. And if down the road we can have ammunition that helps with that, helps us build a stronger case, an even stronger case than what we've built, then I don't see any reason why we can't take that to the government at that point and say, look, here's what you meant to do. Here's what you said the impact is going to be. Here's what the impact really is. What are you going to do about it? But in the meantime, we have to live with what's there. And hopefully what we'll do here today is give you an understanding of what you need to be thinking about today, what you need to be preparing for, what you need to be worried about, what you need to worry less about, what you don't need to worry about. So those sorts of things. And as Russ mentioned, there's a lot of slides, there's a lot of information. It's divided up into sections, but we can take questions pretty much any time. If there's something really burning on a slide, feel free. If it's something we're going to come to in the next slide, we'll tell you that. And there's no such thing as too wacky a question. We may not be able to answer it. Like I said, may go on to the list of things that, that we're approaching the officials about. But it's also about us getting a better understanding from you about some of these issues as well, because you have to live with this more day to day than Imagine does as an umbrella organization. And the better understanding we have, the more we can try to do with you and on your behalf to try to fix what needs to be fixed, if that's possible. So,
quick overview of what we're going to talk about today. I'm going to cover 4 topics. The first topic will be just a general overview of what the legislation is, particularly with respect to the commercial electronic messages, or CEMs. I will talk then about the issues that affect charities and non-for-profits, at least what we anticipate will be your burning issues. Give you some tips of how to prepare. And then at the end, I'll cover very briefly the other legislation requirements that are not commercial electronic message related, so just so you have an idea. So what is the Canada Anti-Spam Legislation, or CASL? Well, I'm not going to read the actual name of this legislation. It's just long and quite a mouthful. That's the official name. Enact or promote, et cetera, et cetera, et cetera, et cetera, et cetera. Unofficially, it's referred to as the Canada Anti-Spam Legislation, or CASL. Personally, I don't like any of these unofficial titles. I think they are misleading. I think the unofficial title should be Canada's Unsolicited Electronic Message Legislation, or something of the sort. It's because when someone hears anti-spam, they think, oh, spam is only that email I get from someone in Nigeria asking me to send them some money, or selling me, a certain drug that helps with certain activities and goes to my spam. So yeah, that's what people think in the back of their mind when they think spam. But this legislation does much more than that, and it regulates much more than that. So background and history, just a little bit overview of what it does. In general, it regulates a broad range of activities that are electronic in nature, all right, which basically is where we live these days. Everything we do electronically. It regulates, as I mentioned, unsolicited electronic messages, such as emails, texts, tweets, et cetera, et cetera. Hacking, malware, and spyware, that's really where they're trying to go at, and I would say, hopefully, everybody here doesn't engage in that activity. Phishing, fraudulent or misleading practices, privacy invasion through your computer, and collecting email addresses without your consent, also known as email harvesting. All very, very good purposes. That's what we all would like to be regulated. And whether or not they're going to be, it does that is a whole different question. And at the bottom there's a website. It's fightspam.gc.ca. That's the website set up by the CRTC, which is one of the bodies that's going to be regulating this act. And a little anecdote, the CRTC had put out, or the government had put out requests for bids for anyone who wants to take on this website and to manage it, and no one bid for it. Absolutely no one. So the CRTC is doing it on its own, and again, query how much resources and how much taxpayer money they're going to use for this. But in any event, yeah, so that's the website. And why is that website important? Because that's the website that any one of you, anyone out there in the world, or in Canada, not in the world, in Canada, can go to if they get an email that they're not happy with, and they can just click and complain about it. And that's how the process starts, where the regulator gets involved. Some fundamental underlying principle of CASL. So overall principle, I think, when you think about this legislation, you got to think about what they are doing. And what they're doing is they basically, any activity that they regulate, or this legislation regulates, requires you to do so with informed consent. Okay, that's sort of the overall principle. But what is, it comes down to what is consent, when you get consent, and that's the details. But essentially, if you're doing it, you got to get informed consent if you fall under the regulated activity. an opt-in regime. What does that mean? Well, when you think about opt-in versus opt-out, most anti-spam regimes regulated in the world where they regulate the spam are opt-out, which means that you can send something until someone says, don't send it to me anymore. Kind of like the do not call list, right? You can call someone until they say, don't call me anymore. This is not the case under CASL. CASL is an opt-in, which means that you cannot send something to anyone until they say, please send it to me. Okay, so it's opt-in versus opt-out. And I mentioned the forms part of our G20 commitments. You can go back to how this started until when this legislation comes into force. Canada was viewed as unofficially the hacking and spammers haven. And we had no regulation about it. And so we got a lot of pressure from our G20 members. And this is where we went. And we basically went from one extreme to the other. And again, it's referred to as probably the most, once it comes into play, the most onerous regulatory regime in the world with respect to spam. So we are now the opposite, being the haven for these kind of activities. What is the purpose of the legislation? Well, according to Industry Canada, the general purpose of CASL is to encourage the growth of electronic commerce by ensuring confidence and trust in the online marketplace. Well, that sounds very noble and exciting. And the reason it's important is when it comes down to actually enforcing this legislation and interpreting it, and when it ends up before a court at some point, because it's bound to end up before a court, the court will look into this general purpose and try to interpret the legislation within this purpose. So, you got to, when you think about whether or not something should be falls within the purview of the Act, you got to think of, well, is it really what the Act was meant to enforce? In other words, the legitimate activity versus the illegitimate activity. 3 important dates to keep in mind when you go through this Act. The first one is coming up, July 1st, 2014. That's why everybody now is yelling CASL, CASL, CASL. So the requirements respecting CMs, which are going to be the focus of this workshop, come into force July 1st, 2014. That's your cutoff date. You got to keep that date in mind. The next date to keep in mind is January 1, 2015, which is when the requirements respecting computer programs comes into place. Not as much, it may not affect many of the organizations or any of the organizations here, but I will cover that a little bit at the end, and that's when those particular regulations, or that particular part of the Act comes into play. July 1, 2017, there's 2 reasons why that date is important. The first one is because we're going to get into it, but there's going to be a transition period from the moment this Act comes into force until July 1st, 2017, where if you already have what is called implied consent, and we'll talk about that, you have until July 1st, 2000. It's extended to July 1st, 2017. And then the other thing is the private rights of action. So when I talk, next slide, we'll talk about what actual what are going to be the results of non-compliance, and one of the things that the Act provides is the ability to sue someone privately. And so that ability to sue someone privately only comes into play on January 1st, 2017. And as I go back again to the important dates as a charity or NPO that you have to keep in mind are July 1, 2014 and July 1, 2017. Those are the big dates. Significant consequences. All right, so some of you must have already heard, oh no, millions of dollars. If you did hear, if you haven't heard, you hear now. If you did hear, you were right. You heard right. Very significant fines are available. The regulator can fine people up to $1 million per violation. That's per one email, and $10 million per violation. Now, there's basically unfettered discretion under at least the way the regulations and the Act is drafted for the regulator to go any way. They can, that means it could be $1, it could be $10 million. So it's kind of difficult to determine where they're going to, what number they're going to go after for each violation. But that's the maximum, and that's that's significant. Private rights of action, I mentioned earlier. Under the legislation, as of July 1, 2017, anyone can basically commence a lawsuit, civil lawsuit, against an organization, against an individual for non-compliance with the Act. That provides an individual who sues for that, so that's anyone who gets an email, essentially, up to $1 million in damages per individual. And I say potential for class actions. You know, think about it. If one email goes out that doesn't comply to 1,000, even 100, 1,000 people, I'm pretty sure the plaintiff side class action lawyers are out there waiting for an opportunity to start a class action. And, you know, and that's for very significant damages just for that one email that went to 1,000 people. And again, that comes into force July 1st, 2017. So at least for the next 3 years, we won't be seeing any legal lawsuits yet. Vicarious liability, the Act provides for liability of corporations for their employees. So one email sent by an employee of your organization that doesn't comply, the corporation may be found liable for that, up to $10 million. And officers and directors as well may be facing a personal liability for any acts of the corporation. And sweeping investigative powers. So the Act provides the regulator, as well as the individual who's suing under it, basically very broad powers to go and obtain search and seizure orders. That's what I would refer to them as, where they can go in and, you know, go through your computers to figure out who sent what and when, yeah, you need to kind of just give them the information. They also have the ability to go and get these orders against the internet service providers, the server people who host your information on their servers, and that way they can basically investigate whether or not, you know, you've complied with the Act, or who at least did not comply with the Act. Injunction. So as well, it provides the regulator, as well as the person who is suing, with the ability to get some orders against whoever it is that's not complying, or they believe is not complying, in order to stop what they're doing, and cease and desist. And if you don't comply, then there's significant, with that order, there is significant consequences as well. So, right. So there's going to be, well, the Act designates 3 bodies to regulate it. The first one is the CRTC. That's the one that will be regulating the commercial electronic messages, and as well as the installation of computer programs part, which we'll be talking about today. The Privacy Commissioner that already is dealing with collection and use, improper collection of use of private personal information. Now it also affects anything online. Excuse me, and Competition Bureau that will be dealing with misleading online advertising and marketing practices. But the CRTC really is your regulator. When we talk about the regulator today, we're really talking about the CRTC. Now you got to keep in mind, CRTC, I'm sure you've heard of them. They you know what, have an idea what they do. Traditionally, they were responsible and are responsible for regulating the radio communication industry, the Rogers and the Bells of the Teluses out there. This is what they deal with on a regular basis, online as well as traditional media. This is going to be a whole new area for them. They, you know, the kind of agencies, organizations, businesses that are targeted it's everybody. So they just, their expertise is going to be different, and as Bill mentioned, their understanding of what any of you do will be likely none, zero, you know, because they don't know anything about that. That's not what they've traditionally been trained to do, or to work with, or deal with, or regulate. So how they're going to respond is we will have to see, like whether or not they'll hire people who understand the industry, maybe, hopefully. Under the legislation, there is a general prohibition against transmitting or sending a commercial electronic message to an electronic address. So it has to go to an electronic address, unless the receiver has already consented. So as I mentioned, it's opt-in. You already have to have consent to the receipt of that message, and that message, that commercial electronic message, contains certain prescribed information. So you have to in order to comply with the legislation, every time you send a commercial electronic message, and we'll talk about what that is, unless you're exempted, and as I said, as you can see, there's some exemptions or exclusions. Unless you're exempted, you must A, make sure that you have consent before you send it, and B, you have to make sure that that message contains certain information. And as well, I'm going to go back to that same day, July 1st, 2014. As soon as July 1st comes, you have to comply with those two requirements. So what is a CM? CM is a message sent by any electronic means. So email, text, instant message, tweet, etc. Anything electronic that has as its purpose, or one of its purposes, to encourage participation in a commercial activity. Okay? So it's any purpose, one purpose, as long as it has anything to do with encouraging participation in a commercial activity, it would be a CEM. Well, what is a commercial activity? Well, the definition under the Act is any particular transaction, and this is a paraphrase, but because I wanted to focus on what matters, what should matter to you. It's any particular transaction or act or conduct that is of a commercial character, whether or not the person who carries it out does so in the expectation of profit. And this was why, in our view, commercial activity, when you hear that, you think, well, we're nonprofits, we're charities, we're not involved in commercial activities. According to the Act, you are. Because there is does not have to be an expectation of profit. And the Act provides some examples. That's just examples that are in the Act. There would be much broader than that, but examples are an offer to purchase, sell, or lease goods or services, an offer to provide a business, sell or lease investment or gaming opportunity, so like a lottery, selling tickets, advertising or promoting any of these activities, and advertising or promoting any person or business that's engaged in that activity. I don't include that part in there, but that's also there. So, do charities and NPOs transmit CMs? The answer is most likely yes. Why? Because of the broad definition of CMs, and particularly the fact that it states that the requirement should not be for profit. Basically, anything that involves commercial exchange, whether or not you intend to make profit out of it, will be covered. So I gave some examples that I believe would be considered a CEM. An email seeking donations will be a CEM. Email seeking volunteers or members for the organization will be likely a CEM. Email selling tickets to a charity event lottery will be CEM. Emails promoting a charitable event. Electronic newsletters might be a CEM, depending on whether or not the purpose is to get some kind of a commercial transaction, like if you have a one-liner at the bottom that says, and by the way, here's our newsletter, and by the way, if you want to donate to us, then click here. That will probably constitute a CM. Emails promoting the organization's work. Also, if it's purely informational, may not be a CM, but if there's some form of request to or a promotion of a commercial activity, somehow say, again, one-liner that says, if you want to learn more about us or you want to donate to us, please click here. Well, not learn more, but donate to us. So it's got to be something that involves, I would say, an exchange of money or an anticipation of the exchange of money, or at some point down the line, the purpose is basically to get money or some kind of a commercial transaction. CM consent requirement. So, as I mentioned, if you send a CM, the Act says you may only do so if the recipient has provided you with express or implied consent. Okay? And the onus of proving consent will be on the sender. So, you think you have consent, you send it, the person says, I never told them, I didn't want them to send me this email, why are they sending me this email? They go and they file a complaint on the website, you get a call from the regulator, and you say, well, we have consent, well, prove it, right? So that's where things get a little iffy, and you got to figure out how you intend to keep track of that, and we'll talk about that a little bit later. Now, here's the other kicker. The Act says that an electronic message seeking consent to send a CEM is a CEM and therefore prohibited. Yeah. What does that mean? That means that, and now we'll talk about the fact that we're going to tell you, here's what you got to do if you want to get consent. You got to send an email out asking for consent. You got to do so before July 1st, 2014. Because after that, if you send an email saying, could you give us consent so we can send you further stuff in the future? Can't do it. That would be as prohibited. Unless you already have consent. And we'll talk about that a little bit later. Yeah, they had to include that in there. Request for, so we'll talk about, so there's two, as I mentioned, there's two types of consent. There's express consent and there is implied consent. Either way, you're good. As long as you have express or implied consent, you can send a CM. Well, what's express consent? The legislation defines that and provides specific requirements about the express consent. So the first thing is you can get express consent by orally or in writing. Doesn't matter if someone says, you say to someone, oh, could I contact you and send you information about my organization electronically? Sure, that's consent. Okay, now you got to prove it. They forgot 2 years down the line, but that's a whole different issue. You got to deal with how you're going to keep track of the oral, which is why it's always good to get it in writing. Request for consent must include the purpose for which the consent is being sought clearly and simply. So it's not enough that someone consented to you collecting their personal information, for example, out of PIPEDA. That's not good enough. You got to actually seek consent for the purposes of receiving commercial electronic messages. All right? They have to understand that when they're clicking yes, they are consenting to getting those messages in the future. All right? That's important. And you have to make sure that it's clear. And you may rely, as I mentioned, you may rely on consent you've obtained previously. So before the legislation came into force, like under PIPEDA, for example, under the privacy legislation, you have to get consent for certain things like collecting personal information. You may do that only if, when you sought consent and obtained it, it was also for receiving electronic messages in the future. So it's not enough that they said we consent to collect personal information or whatever. We consent to the use of your personal information. No, it has, so long as it said for the purposes of sending electronic messages. That's the only way you can rely on your previously obtained consent. Also, the request for obtaining express consent must include the sender's identifying information and on whose behalf it's being sought. So you got to identify if you're seeing it on behalf of yourselves, your organization, a different organization. You've got to identify that. You got to include your contact information so they may contact you. And you have to have a statement that says, you may withdraw your consent at any time. So they know that when they're getting this consent, they can also withdraw it at any time. Implied consent. So as I mentioned, there could be two ways that you can get in consent. You can get it said expressly, like actually someone tells you they consent, or it can be implied, based on a certain, as long as you meet certain criteria or meet certain definitions. So the following situations are where you have implied consent. The first one is called an existing business relationship. I'll talk about that, what that means in a minute. The other one, and that's what's going to apply to charities and nonprofits in most cases, is called the existing non-business relationship. The third is the recipient has conspicuously published his or her electronic address, as an example, on their website. It also has not indicated a desire not to receive unsolicited CMs, and that's the kicker, the message is relevant to the recipient's business role, duties, or functions. So for example, I am a lawyer. I have a bio on my website. My website contains my email address. Here's my email if you want to contact me. Doesn't say don't contact me, don't send me CMs. You send me an email about my business. Could you tell me more about what you do? Or more importantly, I provide this and this services to lawyers, and you may be interested in something of this, or something like this, like a conference, for example, on this. That would be you would have implied consent to send me those emails, because I basically am out there saying, please send me emails by putting my email address out there. And again, the email, the purpose of the email applies to my business as a lawyer. The recipient has, that's the fourth implied consent, another option, disclosed his or her electronic address to sender without indicating a wish not to receive unsolicited CEMs. So for example, someone gives you a business card with their email address on it, and the message is relevant to the person's role or duties in business or official capacity. So again, it's the whole point of, I met someone at a conference, they gave me their email address, they said, here's my, or sorry, gave me their business, here's my business card, we just chatted, okay? And I then want to contact them and say, you know, you'd be interested in maybe in this activity because this has to do with your business or with your role. That would be okay. That's called, because basically when they gave me their business card, they told me it's okay to contact me for the business of for their business purposes. They gave me implied consent. But what you have to remember though about implied consent is, as I mentioned earlier, the onus is on the sender to prove it. So if this person, 4 years down the road, forgot that they gave you their business card, you didn't keep that business card, you didn't keep track of it, you got to then prove that actually they consented, right? So that's where things get a little iffy. So existing business relationship, I said there are two implied consents as well that you can rely on. The first one is the existing business relationship. You can rely on implied consent. You basically implicitly receive consent from someone to receive an email if in the past 2 years, so only 2 years, that before you sent the CEM, this person has purchased or leased or bartered a product, good, service, land, or an interest in land or a right in land from the sender. Or accepted a business, investment, or gaming opportunity offered by the sender. So you sold them a lottery ticket. Or a written contract is created between the recipient and the sender for the matter not listed above. So if you sold a lottery ticket to an event in the last 2 years, you're okay, you've got implied consent to send that person CMs. But 2 years, after 2 years it expires. If you entered into a contract with an organization to provide them with some services, individual to provide them with some services, you're good for 2 years. After that, you're not. Or that's one other thing is you've got 6 months before the message is sent, the sender received from the recipient inquiry or application from one of the items above. So if someone sends you an inquiry and application within the last 6 months about a certain product that you're providing or service, then that's okay. You can contact them for 6 months only. Implied consent for non-business relationship basically says that, and that's why it applies to charities and NPO, that you have implied consent to send CEMs to someone if you have an existing non-business relationship. What is that? Well, the person is, you are a charity, okay, a registered charity, and you have received a donation, or the person that you're sending it to has donated to you, or performed volunteer work for you for the last 2 years, okay? Or you're a nonprofit organization, as it's defined under the ITA, and the recipient has been a member for the last 2 years. So if you're, it basically comes down to this. You're a registered charity, you got a donation in the last 2 years, you're good for 2 years. You can send them CMs. As soon as that 2 years is up, you can no longer send that CM, unless they donate it again, and then the 2 years starts again. If the person performed volunteer work for you in the last 2 years, you're good for 2 years. If you're a nonprofit and someone joined you as a member, you got 2 years of implied consent. You can send them CMs, and you can request express consent. Transitional period, and that's also, this applies to implied consent. So they gave us a bit of a break to give you some time to transition into things. And what the Act says is that you have until July 1st, 2017, in which you can rely on implied consent if you already have an existing non-business relationship. So going into July 1st, 2014, anyone who has donated to you, volunteered for you, or was a member, you got implied consent to send them CMs until July 1st, 2017. After that, the 2 years starts from the moment they actually joined, donated, volunteered. Okay? And basically, that's the time when you should be seeking express consents from these individuals only, so donors, volunteers, or members. So information requirements. So in addition, as I said, to getting consent, you must include in all your CMs identifying information of sender or person on behalf the message is sent, so who you are and who is the organization you're sending the information, the CM on behalf of. as well as identifying information, but must also include contact information. So your address, your email addresses, your website, everything, your phone numbers. Must set out a means by which to contact the sender to be effective for at least 60 days. So when you send the CMs, you have to make sure that the person can contact you within the next 60 days. Why do they put that there? Because some spammers would go, you know, here is this organization, this great, you know, whatever, this, we're selling you this product, blah, blah, blah. Here's our contact information. And then, you know, after about 5 minutes, it disappears and you can't contact them because they don't want you to contact them, right? So you got to make sure that when you send out that information, that if your address changes suddenly or your email address changes in the next 60 days, well, you may not be complying anymore. You got to make sure they can contact you within the next 60 days. Must give, okay, so here's the kicker, and this is where everybody should really be considering and thinking about what they need to do. Must give the recipient a method to unsubscribe from receiving messages. So any communication you send out, any commercial electronic message you send out must have an unsubscribe function. And the person who receives it maybe can easily unsubscribe to receive further CMs from you. And when it's not practical to include in the CM, the information must be posted on a website, and the CM must include a link to that website, which is clearly and prominently set out in the message and is readily accessible. In other words, if you don't have the resources to now go and change all your electronic communications and all your emails to include an unsubscribe mechanism, what you can do, at least what it seems to provide you to, if it's not practical for you to do it, is to include a link in your to create a web page on your website where someone can go and then unsubscribe, and then that link to that website has to be conspicuously on the email that you're sending out, and it should say, if you want, to unsubscribe, click here and go to this website, and then it's got to take you to that website, and that website has to have the unsubscribe function. The unsubscribe has to actually, that shouldn't just say unsubscribe. That shouldn't just say, if you want to unsubscribe, contact us. There actually has to be a function that allows them easily to unsubscribe. So click here to unsubscribe, or if you don't want to receive any more information from us, please click here, right? It has to actually allow them to do that. It has to actually have an electronic address or a link to your website so they can contact you if they need to contact you. It must be effective for 60 days. So what does that mean? It means that if you send a CM and it has an unsubscribe in it, says, which should have an unsubscribe on it, they don't click unsubscribe. OK, that's good. So we can continue sending CMs. You send another CM 10 days later, another one 2 weeks later, and the person just says, I'm sick of this. They can go back to the first CM, going back 60 days, and then click on the unsubscribe, and then still be able to unsubscribe for 60 days. And then also very important, you got to give effect to it within 10 days following receipt. So if someone unsubscribes, make sure that it's given effect within 10 days. So if you send a CM beyond those 10 days and they complain, you got a problem. So you got to make sure to put that, as soon as they unsubscribe, enter them into the do not contact list in your database, and do not contact them anymore. And make sure you speak to anyone else who's contacting them on your behalf and let them know that they can contact them, these individuals. And it must be at no cost to anyone, okay? So if you give them the unsubscribe, you can't charge them anything for it. Registered charities exemption, I think that's, again, one of the ones that anyone here who is a registered charity want to know about, okay? And I believe most of you would be. So as Bill mentioned, through the good work of Imagine Canada and some other stakeholders, the Industry Canada has included an exemption for registered charities. You have to be a registered charity under the Income Tax Act. If you are a registered charity, then you may be exempted from complying with the consent requirements and the information requirements only if the message has as its primary purpose raising funds for the charity. Okay? So that's where the exemption is. It's not a purpose of raising funds, it's a primary purpose of raising funds. So what is the emphasis is, in my opinion, is the primary purpose. What will be considered primary purpose? I put my question there is, would it be interpreted from the viewpoint of the sender or the receiver? What does that mean? Well, at the end of the day, it comes to what the message says. So, for example, if you are sending out an email providing information about how the good work the charity is doing, and I'm sure you all do that, and that's great. At the end of the bottom, it says, oh, if you want to donate more, support us more, and send us some money here, click here. For your purposes, the reason you're sending those registered, at least that I would assume, or most people send this information because they want to solicit at some point donations in the future. This, someone who donated in the past, you want to keep them updated on what's going on because you're hoping that one day they'll send you more money. You can probably argue the primary purpose is, not always, but the primary purpose is to raise funds. From the viewpoint of the receiver, they're looking at this, and they may not be thinking this is what your primary purpose is. They're reading it, and it seems to be information about the charity and what they're doing. So it's probably not exempted. Okay? I'm saying probably not because we don't know. We've put some of those questions to the regulator, and that's one of those one of the many issues we've asked and haven't received an answer yet. But because it's probably not, because it's gray, I would recommend, as a lawyer, I always do that, and err on the side of caution, get consent. All right? Emails that sell, as an example, tickets to a charitable event, is it a primary purpose of raising funds? If the email is solely, here's some tickets, buy these tickets to our charitable event, that's, in my opinion, in any event, I would consider that a primary purpose of raising funds because that's the purpose of the email. You're selling tickets to raise funds for the charity. And someone who gets that email will think that. Yeah, they're not selling it for anything else other than raising funds through the charity. So, possible. Again, what it comes down to, what is the content of the message? What does the message say? Is it primary purpose for raising funds, or is it all other things? And by the way, please give us some money. And I also refer to what does raising funds mean? Is it similar to fundraising as it's understood in the ITA? Or is it interpreted by CRA or different? Bill already spoke about that a little bit, so I won't get into that. But that's one of the questions we put to the regulator and we're trying to figure out, hoping that raising funds is a little broader than just what the CRA understands as fundraising to be. They didn't use the word fundraising, they used the words raising funds. Okay? And this is my view in this. Again, this is all very speculative because we don't know. This act hasn't come into force and we haven't seen it being enforced yet. But in my view, at least based on how this act seems to be written and the stated purpose of the act, the CRTC is probably going to focus less on the intended use of the funds and more on the content of the message. What does the message send? Does it appear to be spam, or does it appear to be something more legitimate than that? So there's some more exemptions you can rely on other than the charity's exemption, especially if you're not a charity, but as well available to charities and non-charities. First one is a CM between individuals who have a personal or family relationship, such as a history of direct, voluntary, two-way communications, but you got to be a personal relationship or family relationship. It's not enough that it's an acquaintance. It's got to be a good friend or something. A CM sent to a person engaged in a commercial activity and consists solely of an inquiry on application related to that activity. So if you're inquiring about something or applying for something, they're okay. Solicited CMs, this is why I go back to how I refer to this legislation as the unsolicited message as opposed to solicited messages legislation. If it's a CEM sent in response to a request, inquiry, or complaint, or otherwise solicited by the person to whom the message is sent, so you're responding to someone, then you're okay. Internal CMs, so if you send within your organization, send from one employee to the other with respect to the business of that organization is okay. But if it's one employee emailing the other employee about a event of some charity that they feel very strongly about, that wouldn't be considered an internal CM. CM between organizations, businesses. Okay, so this is again if it has something to do with the person receiving the email, their business. It's sort of similar to the implied consent, but this one is actually a blank exemption from consent. So if you are one organization sending another email to another organization, and that email has to do with that organization's business, or the person who you're communicating to with that particular employee has to do with what they do in that organization, you're exempt. Okay? So you don't have to get consent. CM sent to enforce legal rights. That's one of the things I'll be relying on pretty often. CM sent with an electronic platform where unsubscribe and identifying information is conspicuously published and readily available. This is the sort of what I refer to the social network exemption. That's how I see it. At least I understood this particular exemption to refer to. It's, you know, you're on your Facebook page and you've got people that like you when you send them a communication within Facebook. And when they joined Facebook, they agreed to receive information from you, or actually joined your page, or whatever, or became a friend on your page. They've agreed to receive this information already, so you're exempt. Tweets are exempt, that kind of stuff. CM sent within a limited access secure account by the person who provides that account. This is what we sort of refer to as the banking portals, where you're getting information from your bank and when you've already logged into your banking system and their software. CM sent by the political parties, so that's the political party exemption, similar to the charity exemption. Primary purpose is soliciting donate contributions. But they also got a primary purpose. So it's not like you guys have the primary purpose, and so did they. If they're sending you an email inviting you to a dinner, and it's not clear maybe from that email that what they're going to be asking for, well, either not asking you to pay for the dinner, and they're not going to be seeking any donations at that dinner, you're okay. It depends again on the content of it. It's very, like, basically worded the same way as this charitable. It came out at the same time as the charities exemption. CEM sent to a foreign jurisdiction, although if you're sending a CEM outside of Canada, although you don't have to comply with CASL requirements, you have to comply with that of jurisdictions. CASL requires you to comply with that jurisdiction's requirements for anti-spam, and some of them, like the Americans, they have their various requirements. If you don't comply with that jurisdiction's requirements and you get a complaint, then CRTC here can go after you for that, because that would be not in compliance with CASL. Two-way voice communications. So you can call someone, talk to them on the phone and say, can I send you some electronic messages? Sure, OK. And now next thing I know, you can send emails. Faxes and voice messages sent to a telephone account. So now you can, send out those blast messages, please donate to us, or whatever. Please come to our event, whatever. That's not a problem. Yeah. Or send faxes. Yeah, exactly. Get consent by fax. OK, so there's a few more exemptions that apply. These exemptions are ones where you still have to have consent to send the CM, but you don't have to have the information on the unsubscribe and all that stuff in there. Okay, they're not as applicable to you, but it's still important that you know them. The first one is the third-party referral exemption. What is that? Someone contacts you and says, someone you have a relationship with, existing relationship with. They say, we think you should contact that person. That person X will be a great volunteer for you, or may be interested in donating to your organization, or just a good contact for business networking. And you then have, you're allowed one CM, one email to that person that you have been referred to say, hi, I'm so-and-so, I work for this organization, I've been referred to you by this other person who said that you might be interested in the following, and then give them some information, and that's good. All right? You don't have to get consent to them to sort of send this unsolicited email to this person because you've been referred to them. However, it's only one email. If they don't respond, you can't follow up with any more emails. And you also have to include the identifying and unsubscribe information. And you also have to, it's a very onerous requirement, because what it does is it says, not only do you have to provide them with the ability to unsubscribe from emails from you, but you also have to then allow them to unsubscribe through the referral. So that person, I send an email to that person to say, hey, by the way, Bill has referred me to you because I think you'd be interested in this in my services, and then you are like, why does Bill refer me to me this, whatever, this lawyer, she's annoying me. So you contact Bill and say, Bill, please tell that person not to contact me anymore. If Bill then doesn't let me know that unsubscribe, and I contact you again, then I'm in violation of your act, and so is Bill. So it's a bit of a, sorry. So you got to sort of basically, in other words, both referral and referee, the person who refers you and you have to allow the unsubscribe in either way. You can unsubscribe through him or through me. Yeah, it's complicated. Provision of quote or estimate in response to a request, so you don't have to get consent to do that. So if you want to give them a quote for something, warranty, we call it product safety, you don't have to get consent for that. CM that delivers a product or service, including updates and upgrades. That's an example of what you said. If you're sending, if it's part of your services that you provide, you send the service by email. I'm sending you a document that you whatever paid for as part of the services. That would be exempt. CM that confirms or facilitates transactions. Someone donated to you, you send them a confirmation. You've donated it. That's okay. CM that provides factual information, so factual information only about ongoing subscription membership accounts, loans. I've highlighted ongoing subscription and membership, so you're just sending information to your members about their membership. Your membership is about to expire, or your membership is in default, whatever whatever it is about your membership, you can send that. Ongoing, you're sending information about ongoing use or purchases or employment relations benefit plans for your employees. So those are the kind of things that are exempted from the consent requirements. They're very specific, probably not as important to you, but it's just one of those those areas where if it doesn't fall under the other exemptions, it might fall into this one. All right, so because we don't have a lot of time, I'm going to quickly talk about issues specific to charities and NPOs. We've covered most of it, but just we'll bring it down to the basics. So the first one, these are basically the issues you need to think about and the questions you have to ask yourselves when you prepare for CASL. So the first question is, does your organization send CEMs? Most likely, as I mentioned earlier, most likely your organization will send CEMs due to the broad definition. Might just be one. Most of them might not be CEMs. Most of the emails may be just purely non-commercial in nature, but there will be some email that's commercial in nature. Now, that being said, you still want to make sure that you understand how many CEMs you send, right? I mean, maybe it's one in a long, like once a year, and so maybe you just have to deal with that, consent for that one email once a year as opposed to once a month. But in any event, some questions to ask yourself there when you're preparing for this are, what forms of electronic communications does your organization use to communicate with internal and external parties? Most likely it will be electronic. I don't know of any organization these days that doesn't communicate electronically. But if you don't need to deal with this at all. You can leave. But email, but these are the kind of things you have to be thinking about. Email, instant messages, text messages, SMS, social network, etc. On behalf of which entities does the organization send out electronic messages? That goes to your question. You have to sit down and think about that. Do I communicate on behalf of another organization, such as a national organization or a sister organization? Do I have other organizations or other individuals communicating on my behalf that are not part of my organization? You got to make a list of those and know that you need to be in touch with them about the CASL. To whom does the organization send communications? That's another thing you got to do. You got to sit down and make a list and think about it. Donors, potential donors, volunteers, other charitable. These are just examples. Charitable organizations, tenants, landlords, clients, suppliers, et cetera, et cetera. And the last question I don't have in there, but that's another one and very important. It just got missed out from the presentation, is what type of CMs do you send, right? So what do those CMs include? Newsletters, requests for charitable donations, invitations. We've heard plenty of other examples here. And if any of the questions, again, I'm going to go on to the next question, is consent required? Because at least from my perspective, I believe that every organization will have at least one CM that's sent out. And if they do, they have to make sure that they implement some form of CASL compliant, well, just think about CASL compliance in any event. So the next question, if the answer is yes, I send out CEMs, the next question is then, well, do I need to get consent? So for nonprofit organizations who are not registered charities, the answer is yes. Unless you fall under the other exemptions that I referenced, which maybe for some of the CMs you might, but mostly you won't, you will need consent. For registered charities, you do not need consent if the CM is for the primary purpose of raising funds. Otherwise, you need consent. And as a lawyer, I recommend to err on the side of caution and get consent in any event, because it's going to be difficult for you or to leave it to your assistant or your employees or your volunteers to determine whether or not they need consent or they don't consent every time they send an email seeking donations. Right? So you want to, at least at the very least, try to get consent and to include the prescribed information. And you can ask yourself as well if, with respect to if you are a registered charity or if you're not a registered charity, do you meet any of the other CEM exemptions? So for example, the business-to-business communication, where you're communicating with respect to the receiving business's role or whatever they're doing. So again, the question, then if you answer any of the second question, which is I do need to get consent, right? Because for some of my CMs at the very least, well then, can you rely on the implied consent or do you need to get express consent? That would be the third question. And to sum up, if you are a charity, nonprofit organization, you have the benefit of implied consent for all your existing donors, volunteers, and or members up to July 1st, 2017, and thereafter 2 years after they donated, volunteered, or joined as members. And every time they do that, every time they send a donation, the 2 years starts again. And if you are planning on relying on implied consent, and if you want to do that, that's your choice. But if you do, you've got to make sure that you're keeping track of the 2 years. So you've got to implement a database where you say, OK, here's where the clock starts ticking. And when it comes to that 2-year mark, something should come up for you as a reminder that you've got to get express consent. So within that 2 years, get express consent. Start harassing them. I'm sorry to use that word, but try to get that expressed. Send them emails and say, listen, we won't be able to communicate with you again if you don't consent. So please do. So going back, this is basically it. It comes down to that recommended risk management practice. Each organization has to sit down and figure out how much. How far do you want to go to be ensured that they're CASL compliant? Obviously, as a lawyer, I say go all the way. Because if you want to be sure that you're complying, you should be seeking express consent from all new and existing donors, potential donors, volunteers, members, contacts, suppliers, landlords, tenants, anyone else on your contact sheet before July 1st, 2014. You want to make sure that you're complying. You can do that electronically before July 1st, 2014. You can do it in any way you want before July 1st, 2014. So that's what I said. If you, as a lawyer, if you want to go to the extreme side and say, I want to make sure I'm compliant and have it, don't have to worry about this anymore, then before July 1st, 2014, I'm going to go and contact everybody on my contact sheet and send them a request for express consent, and hopefully get it and keep track of it. After July 1st, 2014. It's going to become a little bit more, you need to think about other ways to get that express consent. So one way to do it is anytime someone gives you a donation, include a request there. Let's say, please click here to give us consent to communicate with you in the future, electronically. And I'll send you any emails. Done. You provide a service to an individual as part of the contract. Have a part, as a paragraph that says, by clicking here, you consent to receive electronic, or just, check marking here, you're agreeing to receive any electronic messages from us. What you cannot do after July 1st, 2014 is send an email just for the explicit request of consent. So you got to do it as part of something else. Okay? Or if you have, you will at least, at the very least after July 1st, 2014, can request by email express consent from your donors, volunteers, and members within those 2 years. So you can do that. Think about the forms of express consent you want. This is the stuff you have to think about. How do you want to get your express consent? You got it, before July 1st, 2014, any way you want, whatever, doesn't matter. But, well, I shouldn't say it doesn't matter. There's a couple things about electronics. So first of all, regulator says you cannot have a pre-check box. In other words, if you send an email and say, here's our newsletter, et cetera, and by the way, if you want to receive any future electronic messages, you hereby agree to receive any electronic messages for us, and there's a little checkbox there already, and it's checked. That's not good enough. According to the regulator, it's got to be an unchecked box, and you have to give them the opportunity to check it. So make sure you don't have pre-check box. That's something that's very common, actually, with a lot of, at least I know with a lot of businesses do that. I'm sure you've seen that when you've bought products, and there's like pre-check box, and then you just ignore them. Well, and then they said, well, you didn't uncheck it. Well, no, you need to be able to check. You need to require them to check the box. And again, as I mentioned in the beginning, express consent has to make sure that you are asking for the consent for which you're intending to send the email. So you've got it. It's not just enough that it says you hereby consent to us sending you, I don't know, just email or a newsletter, okay? If they consent only to receive newsletters, you can only send them newsletters. It's got to be broader than that, okay? It's got to be, I hereby consent to receive any emails from us, any electronic messages from us. Or alternatively, it cannot be, I hereby consent to the use of my personal information for future contact. No, that's not good enough, because that's not requesting specifically for receiving a commercial electronic message. It has to be, I hereby consent to the use of my personal information to contact me, and also to, or alternatively, to contact me and send me electronic messages, something like that. So it has to be specifically for the receipt of future commercial electronic messages. Then you have to ask yourself, do I need to include the prescribed information in the CEM? We talked about that. So what do again, if you're a charities exemption, you don't need to include the prescribed information. Otherwise, if you don't fall under an exemption, except with the few exemptions that otherwise you have to. So what you got to do is ensure that all electronic communications from your organization contain the prescribed information, contain your identification, contain your address, contain your email account, et cetera, et cetera. Most emails that are sent out these days do already have your information in it. But this is an example. Someone as part of their BlackBerries, maybe in their BlackBerries, they're on their iPhone, et cetera, they're communicating, and it doesn't have your identification in there. Make sure that it does. And then, of course, make sure that they provide the unsubscribe function. So the first question when you're going to prepare for this, I prepared a bit of a flowchart. The first question you got to ask yourself, and just to sort of summarize and caption what we talked about, do you send CEMs? Okay? It says no, and if you do not send CEMs, which is unlikely, but that could be, then you have no further action that you have to take. You're good. Okay? Most likely, you got to go to go down, and yes, most likely. The next question you should ask yourself, are you a registered charity? If the answer is yes, then you may be exempt from complying with the CEM requirements if the primary purpose of the CEM is to raise funds for the charity. Okay? You may be exempt. If the answer is no, or you're unsure because you're not sure if it's a primary purpose, then you got to go to the next step. Can you fall under one of the other exemptions? So for example, is the CEM an organization-to-organization CEM, and we talked about that a little bit earlier. Is it a personal family relationship? Is it internal? Is it an inquiry application or a response to an inquiry and application? Or a complaint, enforce a legal right, within a secure access platform? Or a platform that provides the option to unsubscribe, such as the social network, or to a foreign jurisdiction. So if the answer to any of those is yes, with respect to the CEM, no further action required. If you answer any of these questions in the affirmative. Is it a third-party referral? Are you providing a quote or an estimate? Are you providing warranty, recall, or safety information? Are you delivering a product or a service? Are you facilitating or confirming transactions? Or are you providing factual information about ongoing subscriptions, et cetera, ongoing use, or employment relations, et cetera? If the answer to any of those is yes, then you do not need consent to send that CM, but you still have to include the identifying information on the unsubscribe. If the answer to any of the exemptions is no, all the exemptions, in other words, there's no exemption that applies to you, then the next question you should ask yourself is, the answer would be you need to get consent. So the next question you have to ask yourself is, do you have implied consent to send the CM? Do you need express consent? Consent is implied, to remind you, with respect to registered charities or nonprofits, if the recipient is a donor, volunteer, and member in the last 2 years. Okay, so then you don't need to get express consent. You already have consent. If the answer to that is yes, your implied consent is good for 2 years. So what do you need to do then? You still need to include the prescribed information in the unsubscribe. You have to keep track of those 2 years. And you have to make sure you get an express consent within those 2 years. If the answer to that, the question of do you have implied consent is no, or you're not sure if you have, then the recommendations are, before July 1st, 2014, obtain express consent, include prescribed information and unsubscribe mechanism in all CMs. After July 1st, obtain consent in the prescribed form, as we talked about earlier, not as a separate email, but in other ways. Include prescribed information and unsubscribe mechanism. So, in addition to that, some more general tips of compliance to help you with your preparation. So the first thing, before July 1st, 2014, we recommend develop forms, actual forms for CASL compliant communications containing the required unsubscribe mechanism. So basically, figure out how you are going to comply with the identification and the unsubscribe. As an example, do you want to have an actual link that says if you click, or like actual box where you say, please click here to unsubscribe? Do you want to have a link to a website that provides the unsubscribe? Or do you want to say, if you want to unsubscribe, please send us an email that says unsubscribe? Or don't send me any more information or something. But you got to figure out how you're doing it, and it's better to be consistent just because that way you know that it's followed and it's easy to follow. Develop the required unsubscribe mechanism. Develop an implementation and training program. That's for your employees and your IT and your management. Basically, I've got to come up with that. Develop policies and procedures for CASL compliance. So as I mentioned earlier, in your policies and procedures of your organization, have something that says, here's what we've got to do to comply with CASL, and train and educate management, staff, and volunteers and employees. So why do I say all those? The last 3 points are important because of the due diligence defense, which is what? If something happens, your employee makes a mistake, an assistant, a volunteer sends out an email on your behalf asking for whatever it is, and it doesn't, you don't have consent, it doesn't fall in the exemptions, and someone files a complaint, regulator comes after you. You have the option of the due diligence defense. If you can show that you were diligent, that you have policies and procedures to comply with CASL, that this was a one-off thing, it was a mistake, it was legitimate, and you have done what you need to do to train and educate the people who are sending CMs on your behalf, then you can probably get off. Well, you will have that defense in any event, right? You got to make sure you have something to put before the regulator to show that you've done your due diligence. Ask yourself, and this goes back to the whole sending those emails and saying unsubscribe. What processes do you want to put in place to address the opt-out request by reply, message, phone, or individual employees? So someone calls and says, stop sending me any, I want to withdraw my consent, or I don't want to get any more information from you. What are you going to do to make sure you keep track of that? You got to figure out a way of keeping track of entering into your database or something similar. Someone sends those emails back saying, don't unsubscribe, take me off the list. Someone's got to be at the receiving end to implement that within the 10 days. So make sure you know how to do that, or you have a way to do that. Ask yourself, what third parties have been retained to send CMs on your organization's behalf. Who is sending the CMs on your organization's behalf, such as an individual who is asking for toys, as an example we had here. Then you got to put in policies and procedures to require compliance. So again, if you have the policy that says if you are going to send something on our behalf, please make sure you do the following. Make sure you have consent. Make sure you only do this to the individuals who you have consent. Make sure you only have a personal business relationship, whatever it is. Make sure you contain this information. And it's in your policy, and you communicate it to this individual, but this individual just ignored it and did it anyway. Well, then possibly you can raise a due diligence defense. Said, I did my best I could, and this person just wasn't following. Whether or not that will help you, possibly. Review your contracts with third parties, require CASL compliance. That was exactly an example that this lady at the back said. If you get into an agreement with organizations that rent out the theater, for example, as part of the agreement, have a CASL compliance requirements. Consider buying insurance for CASL. I'm not an insurer. I'm not trying to sell anything. You know, I'm sure the insurers are already out there building some kind of insurance policies to cover you for these kind of things, and so that might be something you want to consider to add to your already if you have the directors and officers liability insurance, which I'm sure most of you do. Much of the preparation is IT dependent. Meet with your IT guys. If you don't have one, just there's again, I'm sure there are consultants out there, and I don't know anyone in Edmonton. I know some in Toronto, but I don't know in Edmonton who are specifically working on consulting and helping organizations implement IT databases and IT functions to comply with CASL. You know, review your IT systems. Make sure you have a way to obtain express consent electronically to maintain the database that says here's all the people who consented, here's all the people who didn't. Keep track of that. If you intend on relying on implied consent, figure out a way, perhaps through your IT systems, to keep track of your donors, your volunteers, and your members that 2-year period, and have what I mentioned earlier is the tickler system, what I call a tickler system, like a reminder. When this comes up, I don't know, whenever you feel it's appropriate, 6 months before the 2 years, reminder that says it's time to send, or even automatically as a year passes or 18 months passes, and you want to just have your system send out emails to the individuals saying, please give us our consent. We may not, come this date or this day, we won't be able to communicate with you. So that kind of stuff. Ensure all electronic messages are sent in prescribed format, so they have the identifying information in them. Ensure you have the unsubscribe mechanism. We've talked about that. Again, that's all IT-based, or most of it is IT-based. Ensure that you implement the unsubscribe within 10 days. We don't have much time, so I do want to just cover the last sections of what the Act deals with other than CMs, which some of them might actually apply to some of your organizations as well. So the first one is the installation of computer programs. Basically what it says is it is prohibited to install a computer program, such as a software, an app, etc., on a computer or device, tablet, phone, whatever it is, in Canada without the express consent of the owner. Okay, so you cannot install that upgrade or that applies as well to upgrades and updates of any already existing computer programs. So you got to get that consent first. With some exceptions or some assumptions of particular programs, and just with respect to the coming into force, that particular section of the Act comes into force January 1, 2015. So there's a little bit more time on that one. Does this apply to you? Well, it might. The requirement may apply to your organization. You have to ask yourself. You have to do a little bit of a review of your organization and how it functions online. So of course, if you're in the IT business, it definitely will apply to you. I almost guarantee it. If you're not, you've got to ask yourself, does your organization have an app or for mobile devices? A lot of organizations do. So it will apply to you. Does your organization provide services through a computer program? I give an example in instructional video games. I personally know some nonprofits who educate children through particular video games. That's an example of providing a computer program. Does your organization provide a program for its employees, members, donors, etc., to be used internally to communicate with the organization? Remote access, as an example. So if you have a remote access system where your employees can communicate with you, do remotely access their desktop, for example, that particular function may actually require an installation of a computer program on their computer, and therefore that would be captured under the Act, and you have to get consent from those employees to do that. There's also particular functions of programs that are being regulated. So you got to ask, does your program collect personal information? Does it interfere with the ability to control the device? Does it change settings? Does it interfere with data? Does it communicate with another device without the knowledge of the owner? Or does it install software that can be remotely accessed by a third party? For example, remote access, that's one of those particular type of softwares. If yes, if the answer is yes to any of those, then you have to seek express consent for that purpose, and you have to explain that purpose in very clear and lay terms to the person who is agreeing to that, consenting to it. That's basically a very short, very quick review of the computer program requirement. The next requirement is electronic, or the next regulated section is the electronic collection and use of personal information and address harvesting. Basically, CASL prohibits anyone from using electronic systems to collect and use personal information and email addresses without the express consent of the person whose information is being collected or used. So you cannot collect the person's personal information online or their email addresses without their express consent. So you got to think about your online marketing strategies. There's a lot of, most, at least I know in the business community, a lot of the online marketing is done now through this type of activity where there's code out there that reads people's email addresses, what websites they go to, et cetera, and that they target them for marketing purposes. You can't do that anymore without consent. You should consider eliminating the practice or obtaining consent. Misleading online marketing and advertising, that's pretty obvious. Can't mislead online through your marketing and your advertising. It's basically it's already existing legislation out there. It's just updated to finally to apply to online marketing as opposed to traditional marketing. So I've given you a couple of, 3 websites there. That's some of the ones that I know of, which is, one of them is Miller Thompson. We have our website, on our website, anti-spam legislation resources. We update it regularly. We also, you can subscribe and consent to get messages from us, particularly about anti-spam and any news and anything that comes up. And if there's any, hopefully more clarity from the regulator, we will put it out there. So you're certainly welcome to go there for information. There's 2 websites there. One is the CRTC and one is the Industry Canada, both of which are supposed to be updated regularly by the government and to provide information. How far and how often they'll do it, I don't know. But those are some of the resources I use in any event. And that's it. Bill, yeah.
And as well, as and when we get any clarification from anyone in the officials regime as to some of the questions that we've got, some of the gray areas, to the extent that we get any answers from them, we'll be using our channels to put those out. So if you're members and you're subscribed to Imagine Matters, or if you have liked us on Facebook, we'll put it out through our Twitter feed. We'll put the information out through all the channels we have at Imagine Canada as well, and keep people as up to date as we can on any developments. And then as well, like I said, to the extent that any of you take any action, whether it's just quantifying things, measuring the impact on yourselves, if you come up with more questions, more scenarios, if you have contact with your MPs to let them know or ask their clarification on things, just please drop me a line. I've got a stack of cards out at the table at the outside. Drop me a line. The more information we have, the more we can bring to bear if and when we get the opportunity to make this an issue again. I have a feeling it is going to be an issue again. It's going to be an issue with the private sector as well as with us. And the more we have, the stronger a case we can make at that time. So,
all right, let's draw this to a close. First of all, a big hand for our two presenters. And I'm happy to tell you that on our collective behalf, in lieu of a gift to Bill and Manit, we have agreed with them to make a donation on your behalf to a charity of their respective choice. So that we'll be thanking them for spending time with us. And I'd like to just, I guess, offer, and please correct me if I've missed the boat here, but just a couple of simple practical things to maybe take away. Figure out who in your organization is going to get on top of this, because somebody needs to understand it. So something to think about is, so who in your shop would get on top of this for you? Head toward getting consent. It's probably the best way to go. There are exemptions, as we've heard, but I think that's not a bad thing to think about. How many of you actually have an IT department? All right. What? So it was mentioned, and I just want to point this out, is that there are some really good third-party mass mail services. And they are on top of this unsubscribe thing, and they're not that expensive, so you can check them out. There are several. Many are in the US. I think there's a few in Canada, but it's the unsubscribe thing that you need to work with. And if you are looking for a member management system, there are some very inexpensive cloud service providers that will give you opportunity to create a website, to have a member database, and they provide an email service. It will keep track of memberships and will let you register people for events you have. So there are services out there, and they're not very expensive, frankly, on a monthly subscription basis, like $25 or $50 a month, that will give you all you need to do your business online. So if you're operating in a situation where you think, maybe we should improve our tool set, take a look and just see what's out there. And I think it was just mentioned, get to your people before July 1st. So if you're looking to consolidate your list and get that express consent, you've got some time, but don't sit on it because time goes by quickly, as we know. And I guess the other thing I'd offer is on your website, have a big old button that says subscribe, so that it's easy for people as they come to your website to hook up with you. Because really what we all want is, I think, as Bill mentioned, not to lose our ability to communicate with our community. So I think the easier we make it for people to hook up with us, the better. So those are just a few kind of practical comments that occurred to me as we kind of made our way through the afternoon. And in our typical fashion, we will survive, we will overcome, and we will find a way to do this. And certainly, I think Bill makes a good point, is that it's worthwhile letting your MP and others know, so certainly connect with Bill, connect with us. This is going to be a bit problematic, and we need to let the policymakers know that you've created a problem for us. I think I was astounded at the assessment that this regulation regime will not cause any problems or generate any costs. It's like, are you serious? Because I think it will. I think it will cause all of us some extra work. So at the end of the day, let's make a little noise. I think if there are concerns as they roll into your shop, it's worth letting your MP know. Thank you for taking time to join us. I hope you found this useful. We will be in touch with you to connect you with the video of today, as well as some other information, so you can look forward to that coming in the not too distant future. Our technical people will be doing some work to edit and package all this up, so it'll be a bit before we get it out to you, but it'll be a resource available to you. So green lights and happy trails, and keep up the good fight. Thanks for coming.